Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Barry Nigro. Today's topic is antitrust violation or environmental saving grace, the controversy surrounding Brazil's Soy Moratorium. In an effort to promote certain societal objectives, both government and private firms sometimes take action, be it cap and trade on carbon emissions, adhering to child labor standards, or complying with industry-specific expectations regarding clean labeling. There are various ways in which the government and private entities each promote socially responsible activities. What happens when private agreements differ from or potentially exceed government-set standards? Are such private agreements indicative of cartel activity in contravention of antitrust laws? And how can firms pursue their goals without garnering antitrust scrutiny or worse, incurring antitrust liability? Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Barry.
Anora, who's our guest today?
Eduardo Frade is a partner at Mattos, Filho, a Brazilian law firm where he focuses on antitrust and corporate investigations. He advises clients on a variety of matters, including regulatory, mergers, cartels, compliance, and more. He's recognized for his work in the Brazilian Competition Agency, Administrative Council for Economic Defense, or commonly known as CAGI, including as the General Superintendent, where he was in charge of overseeing merger reviews and conducting investigations. Eduardo is a member of the ABA Antitrust Law Section's International Cartel Task Force and has consulted for the Inter-American Development Bank and Organization for Economic Cooperation and Development. His knowledge of cartels, experience at CAGI, and work as a private sector antitrust attorney place him in the perfect position to inform today's discussion on the global legal and economic circumstances surrounding Brazil's Soy Moratorium agreement. Without further ado, welcome, Eduardo.
Thank you, Anora. Thanks, Barry. Happy to be here. Hello, everyone.
So to start, maybe you give us a little background. What is the Soy Moratorium and what are the goals of its formation?
Okay, sure. So the Soy Moratorium, it's an eco-label, right? It's an eco-label that certifies that a company, such as a trader, does not acquire soybeans from deforested areas in the Amazon. So that was the goal of the moratorium. It was created in 2006, 20 years ago. It came out of a Greenpeace report on deforestation in the Amazon forest, which drew a lot of attention. It created a lot of pressure from civil society, from government bodies itself. Most importantly, it created a lot of pressure from large customers that acquire soybeans from Brazil that basically sent a message to Brazilian traders saying, we will no longer acquire soybeans from deforested areas in the Brazilian Amazon. So that generated this sort of an agreement, which is, as I said, an eco-label, to certify that these companies are not acquiring soybeans from the deforested areas. The goal, as you can see, is if you get Brazil, which is the world's largest soybean exporter by far, to stop it from deforesting areas in the Amazon in order to get soybeans. The Amazon is the largest rainforest in the world. So you get the largest soybean exporter in the globe, the largest rainforest in the globe, and you try to come up with an equilibrium here that stops deforestation in these areas. It's a voluntary agreement. So if you're a trader, you can either join, you can withdraw whenever you want. And as of 2009, it was actually co-signed by Brazilian environmental agencies as well. So it has become public policy in Brazil too.
And how did you personally get to know about this moratorium?
So the moratorium is well known, of course. It has been well known in Brazil and worldwide for over 20 years. Personally, in 2025, so last year, we had associations that congregate soybean producers in Brazil, certain parts of Brazilian parliament, other associations, other agents, who filed a complaint to Brazil's antitrust authority, claiming that the soy moratorium was an antitrust violation, that it was a sort of a buyer's cartel. The General Superintendency of CADE, Brazil's antitrust agency, rendered an interim measure suspending the moratorium, which was a very aggressive move. And as you can imagine, this created a whole legal battle. I was called in to represent one of the defendants in this case, and hence my involvement.
And what groups are for or against? I just want to get a sense of who are the players or who are the stakeholders, and why are they for or against the moratorium?
Sure. So obviously, I mean, players who are for the moratorium, environmentalists, NGOs, Brazil's government bodies that are in charge of environmental policy. You also have interesting government bodies that are pro the moratorium in Brazil. It's the case of the Federal Prosecutor's Office, for example. And most importantly, as I said, you have large customers that acquire soybean in several parts of the world who have started to demand that. Not only them, but some of their national governments as well. And of course, this come out of a pressure from their consumer base, who over the years has become more and more interested in acquiring goods that don't come from environmentally flawed products, right? So all of this part is in favor of the soy moratorium. On the other hand, you have soybean producers in Brazil. I would say that not all of them, but several soybean producers in Brazil claim that the soy moratorium is limiting their production. And so of course, they're against that in certain parts. You have landowners in the Amazon who also have a claim against the soy moratorium, because a deforested area in the Amazon is much more valuable than one that is covered in forest and that you can't use for anything. So the soy moratorium, in a sense, devaluates land or these landowners. And you have several important political sectors that support these agents as well. So certain parts of Brazilian parliament, certain state governments that support these soybean producers, they have voiced against the soy moratorium.
Sounds like soy moratorium has been in existence for a while, and as you have explained, there are multiple players in the landscape. But why have the multiple legal challenges? I guess not suddenly, but being initiated now, somewhat 20 years later.
Yeah. So this case, I think it represents an interesting clash, right? On the one hand, you have Brazil, whose economy is largely based on agribusiness. Brazil is an agribusiness superpower. And on the other hand, you also have Brazil as home to some of the world's most important natural resources. The Amazon is one of them. So you see this clash in Brazil, as you've been seeing in several other countries as well, right? This clash that sometimes environment collides with economic goals. You see a lot of people that try to get these two things together in the same site, but you see lots and lots of clashes, not only in Brazil, but in other parts of the world as well. So this is obviously true here in Brazil too. And over the past 20 years, it just grew into a crescendo, let's say, in which the political context and also the legal context led to the moment in which we are now, in which this is colliding very, very heavily. And when you put this on paper in legal procedures that have to be answered by competent authorities at some point, that's where we are now, right? So I think that's why this became something that needs a response at this time.
So I find this really interesting just from a U.S. perspective, because it's familiar in the sense that the government here, whether it's state or federal, often gets involved in social and policy issues. And sometimes they're in tension with, what we're familiar with from an antitrust law, competition law perspective. Can you talk about the government's role in the moratorium and deforestation policy at large?
Sure. And just so what I'm going to say now becomes a little more clear, we haven't talked about that yet. The ecological importance of the Amazon forest is huge, right? So the Amazon forest is a major climate regulator of the planet. It influences rainfall patterns in South America. It is the most diverse ecosystem in the world. And it's important importance comes a lot from the size of it. So the Amazon forest extends through 9 countries. If you get the Amazon region within Brazil alone, this is 40% the size of Europe, right? So you get how important this is, and at the same time, the sheer size of it shows the daunting task that supervising deforestation in this area is, right? So this is really, really a challenge. And in the past year, the moratorium has become such a relevant instrument against deforestation in the Amazon that it has actually been made part of Brazil's official environmental policy. So just to name a few government agencies that are involved in that, you have the Ministry of Environment in Brazil and the Brazilian Environmental Agency, who have formally co-signed the Soy Moratorium in 2010 and who have a role of supervising it, providing support to the moratorium. You have a very interesting role played by a federal agency who is the National Institute for Space Research. So it's an agency that provides technologies such as satellite supervision, for example, that oversees deforested areas in the Amazon, and therefore it helps to oversee compliance to the soy moratorium rules. From a legal perspective, you have support by the Federal Prosecutor's Office, by Brazil's Federal Attorney's Office. You have trade authorities who are involved as well because it has such major repercussions from a trade perspective. Now you have several authorities debating the legality of the moratorium as well, right? So you have, as I mentioned, the Antitrust Agency, but you have federal courts, you have state courts. More recently, and most importantly, you have Brazil's Supreme Court. So it has really become an environment in which several governmental bodies are involved. So it's a huge deal from an institutional perspective as well.
Now, the more you talk about it and the overlapping jurisdictions, the more familiar it sounds to somebody who practices in the U.S. As you know, we often wrestle with state and federal policies that sometimes are in conflict. Can you say more about the forest protection laws and how their requirements are up for interpretation and sort of some of the differences between the positions that parties are taking?
Sure. So to be fair, it's not like soybean producers in general are against environmental laws and they want the soy moratorium environmental laws to be completely dropped. That's not what they're claiming. But there's some interesting legal debates there. So one of them, for example, is the following. If you get Brazil's forest protection laws, soybean producers claim that this law requires 80% protection to lands in the Amazon, right? So that supposedly the law would allow for some room for deforestation in the Amazon. Now, if you get other environmental law specialists, some of them will say otherwise, right? Some of them will say that the goal of the law and the goal of the policies is 100% protection. So there's a clash between theses out there. So that in itself creates an interesting legal debate. But the fact, though, is that despite these national laws in Brazil that completely or partially protect the Amazon from deforestation, you have a scenario in which you have large customers in other parts of the world and also national governments in all the parts of the world that require that the soybeans that they acquire come from 100% protected areas, right? So how does this converse with laws in Brazil? And as a soybean trader, what do you do with that, right? Because you have the laws of the national country, but then you have the laws of other countries, and you have your clients saying, if you don't protect 100%, I'm not going to buy from you, right? So that creates an interesting and very challenging environment.
Yeah, so this might be an obvious question, but does the government's involvement in the moratorium give it more or less legal weight?
Yeah. So I think this is very, very, very relevant. Right? I think it gives a lot of weight, both from a political perspective, but also from a legal perspective. Because, if you get a regular illegal cartel, which is usually a secret agreement between private parties, this is very, very different from a scenario in which you actually have federal agencies that have co-signed that agreement, that openly support that agreement, that say that that agreement is important for certain public policy goals. So I think having at least parts of the government supporting that and co-signing that agreement creates a very, very different legal environment from what would be a usual cartel, right? So I think this is very relevant indeed.
Yeah, so we talked about CAGE earlier, the Administrative Council for Economic Defense, which is Brazil's competition regulator. My understanding is they've initiated a challenge to the Soy Moratorium, and that the challenge is based on the allegation of cartel activity by the signatories. Can you explain what CAGE's concerns are and the evidence on which they're relying?
Sure. So when it comes to evidence, this is a curious cartel investigation because usually one of the hardest parts of a cartel investigation is discovering the evidence, right? Which is not the case here. The whole thing is very public. The facts are there. It has been known to the government and to society for 20 years that the soy moratorium exists. Its rules are in the internet for anyone to see. So it's not really a debate on evidence. It's more of a debate on the merits. And then the accusation against the soy moratorium is a classic accusation when it comes to this clash between sometimes sustainability agreements and antitrust laws. So basically, what the accusers say is that competitors, traders that compete amongst themselves for purchasing soybeans and then selling soybeans, came up with this agreement to allegedly seize or restrict the purchase of a product, in this case soybean, from producers, and that therefore this is harming producers. So it's a classic buyer's cartel allegation. In parallel to this allegation, of course, they also claim that environmental laws that would allegedly support this agreement should not play a role in the antitrust analysis, right? That antitrust laws does not provide room for environmental laws to weigh in. So that's basically it. It's an allegation of a buyer's cartel.
These sort of hybrid situations where you have private actors working alongside the government to, engage in joint actions, so to speak, can be very confusing. What under the law, what would CAGE have to prove to show that the activity here is illegal? And is this the sort of thing that would fall into the per se category? In other words, that it's illegal without regard to justification?
Yeah. That's a great question, and it's perhaps the most relevant question when it comes to the antitrust analysis here. What is the standard for analysis here? Is this a per se violation of antitrust laws, or is this a rule of reason type of case? If you get the decision by the general superintendent who applied an interim measure to suspend the moratorium, it was a very aggressive approach. So it was a fully per se approach. It compared the soy moratorium to a classic buyer's cartel. It claimed that this was a per se violation, and that was it. It didn't get into the merits on whether it was justifiable or not, whether the effects over competition were significant or not. It just assumed that it was. Now, in my opinion, this was a mistake. And also, when the case went up for review by CAGE's tribunal, although there's still a lot of divergence between the commissioners on the merits of the case, all of them unanimously considered that this should not be reviewed under a per se approach, that this should be reviewed under the rule of reason. I think that's the right way to go. The per se approach is an unfortunate one for two reasons at least. So the first reason is that if you take a per se approach, you ignore a lot of antitrust literature that is already out there. You ignore actually some regulation that is already out there, such as European regulations, that allow for sustainability agreements to converse with antitrust laws. And this is, of course, a rule of reason type of approach, not a per se approach. The second problem with a per se approach is that you don't allow room to discuss the legitimacy of the soy moratorium, which in my opinion is sort of obvious, and you don't allow room to discuss the effects of the soy moratorium. even over competition. And here's an interesting field of debate in this case, because the effects of the soy moratorium over the economy in Brazil, even by standard, usual antitrust types of data, was a very positive one and not a negative one. So if you allow for a rule of reason analysis, you can actually analyze that, see that, and review the types of effects that you had, which a per se approach does not allow for.
That sounds familiar to us in the U.S. and under the law, there's often a distinction made between private actors coordinating directly among themselves and situations where they get together to lobby the government to adopt certain policies and then in response to those policies act consistent with them. So in this case, how does the conflict between the Ministry of the Environment, which, as you said, is pro moratorium, and CAGE, which is focused on competition, play into the findings regarding whether or not there's an antitrust violation here? Does it matter at all?
I think it definitely should matter. It's still we're still waiting on the result of that, but in my opinion, it definitely should matter. It's you have two federal agencies here in the same level, right? You have the environmental agency and you have the antitrust agency. One of them, the environmental agency, is openly saying to their sister agency that policy is very important to their goals. It's very important to a whole set of laws in Brazil, that it's crucial to these laws. It seems odd to me that an antitrust agency could just ignore that. It brings about a debate on why would the will of the antitrust authority, if in the end it's against that, why would the will of the antitrust authority be more important than the will of the environmental agency? So there's definitely a very relevant debate to be had here, to the point in which you even ask yourself, and this is part of the allegations, why is this being debated within an investigation instead of within a conversation between federal agencies, right? Would this not be a better case for competition advocacy instead of an investigation? Right? So this is an important debate.
Is there any evidence that the moratoriums harm competition?
So to be fair, of course, if you're the accuser here, you will say that yes, you'll say that an agreement between competitors to somehow restrict purchases will definitely affect suppliers, and that's what they're claiming. I think this is a simplistic approach, though. I think it's interesting to look at the data, which the agency haven't had the chance to look at by taking a per se approach at first. So if you look at the data, it's very interesting, because the fact is that what the soy moratorium did is assuring that not only Brazil kept a large consumer base overseas for its soybeans, but it allowed this consumer base to expand. So it assured that Brazil kept a demand for its soybeans. By doing so, it also allowed Brazil to increase production. It encouraged Brazil to increase output of soybeans. And the numbers show that. The numbers are very interesting. So since the start of the soy moratorium, if you get areas in the Amazon producing soybeans without deforestation, these areas increased by 400%. Production and exports of soybean from the Amazon forest in Brazil during the soy moratorium increased by over 500%. Now, if you get the same rates of increase in other parts of Brazil, this is not 400%, 500%. In other parts of Brazil, it's 100%, between 100% and 200%. So we actually had an increase in output and production of soybeans in the Amazon forest higher than in the rest of Brazil. In my opinion, this goes to show that an increase in production and output in the Amazon did not happen despite the soy moratorium. It happened because of the soy moratorium. And the reason for that is that the soy moratorium assured consumer markets. And very interestingly, the soy moratorium encouraged productivity gains in the Amazon. It obligated soybean producers to produce more within the same amount of area, which is really a lesson to other parts of Brazil and I think even other parts of the world as well. So if you get this whole picture, when you stop to think about it, soybean producers in the Amazon were not harmed by the soy moratorium. They were actually benefited by the soy moratorium. And all that with a significant reduction in deforestation secured by the moratorium itself.
If the moratorium were to lapse, what do you think the commercial repercussions are likely to be?
It's a good question because, as I said, Brazil is the largest soybean exported producer in the world. So the soy moratorium has definitely had an impact on Brazil's foreign trade, and I believe that it still does. If you get an example during the short period of time in which the soy moratorium was suspended until it was reenacted by the judiciary and by Brazil's tribunal, you saw several voices of concern that the suspension of the soy moratorium could cause Brazil to lose consumer markets to other countries such as Argentina and the US. You got some trade disputes. You saw some allegations that without the soy moratorium, Brazil will allegedly benefit from the lack of environmental laws, which seems to be a bit of an exaggeration, but this was used in foreign trade disputes as well. So the soy moratorium definitely has a role when it comes to trade and commercial disputes.
So obviously the soy moratorium is an ongoing operation and legal challenges are still unfolding and controversy, as we have talked about, is still a current situation. But in your view, has the moratorium been successful in accomplishing its goals when it, wanted to achieve when it was formed? And if it was successful, how do you attribute the success to? What are the factors that you would consider?
I think it has been very successful. I think there's no doubt about that. As I mentioned, from a productivity perspective, from an increase in demand and increase in production, the numbers show that it helped a lot the economy. But when you take its main goal, which was to reduce deforestation in the Amazon, the numbers are also very interesting. A recent analysis by Greenpeace, for example, showed that in cities under the soy moratorium, the reduction in deforestation was in around 69% between 2009 and 2022. So that's a very significant number. And unanimously, environmental agencies, NGOs attribute much of this success to the soy moratorium.
When we consider the merits of moratorium, one obvious question we might ask, is it necessary for all the goals, all the good that we're trying to achieve? Well, free markets, I guess, without a moratorium, be able to sustain anti-deforestation practices? And how would you react to that kind of view?
Yeah, that's a really great question. I think one of the good things about the debate that is happening here is that, of course, it's a challenge, but it also creates an opportunity to debate this model and eventual improvements to it. So an interesting question is the soy moratorium as it is it still necessary in the same model as it was 20 years ago? And you've had several changes going on. One important change is technology, right? That I think impacts this debate in two ways. So one of them is overproductivity. So that, of course, has a huge impact in this whole situation, but also technology to supervise deforestation, which, as I mentioned, is something very, very hard, very challenging, but technology is more and more helping with that. And one question that arises from this is perhaps now the government itself can take a more central role in controlling illegal deforestation in the Amazon, and therefore maybe private parties don't have to take the burden of doing that. So that's one interesting question that's out there. It raises a question on whether now maybe companies could more, from an independent perspective, comply with environmental laws. I think it's an interesting debate on whether or not an agreement in the same boundaries as the previous one is still necessary in the same way. It's a tough question, but I think it's open for discussion. I think there's definitely room to discuss.
So let's look ahead and let me ask you a practical question. Let's say that the moratorium is determined to be an illegal cartel or otherwise expires. What does that mean as a practical matter? Is there a way for industry members to come together to address, geopolitical or climate issues or things of that nature without running afoul of CAJE or other competition enforcement?
The answer to this question is already being designed and definitely already being applied as well by certain countries. One of the most important examples are the European guidelines on cooperation agreements. It has a chapter on sustainability agreements that I think shows the path on how this can be made. It gives room for private parties to come up with instruments to encourage sustainability at the same time that it gives guidance for them on how to do it without breaking antitrust laws. And I think this is definitely possible. I don't think these are opposites that cannot be conciliated. I think there's definitely room for that. I think this is 100% possible.
Before we wrap up, Anora and I have a couple of fun questions for you. Anora, why don't you go ahead and...
People listen to your podcast to learn about your insights on subject matters, but they also want to know you as a person. So I guess I'll take this opportunity to ask you to share one thing that people would not know about if they had only known you professionally.
Okay. So I think one thing most people won't know is that I'm a fan of literature. But the interesting part about that is that because of that, I've developed some peculiar habits. So first of all, I don't like translations. So I've learned to read in a bunch of languages so I can read the originals. I only read on paper, so I don't like reading fiction on a screen. And also I have this weird mania, which is I don't like to buy several books at a time and keep them on the shelf. I take keen pleasure on buying a new book and reading it right away. So when you get all of that together, it's very challenging for me to actually read a book because I have to plan, right? I have to plan on getting a book on paper to read at a certain time in a certain language. So it's challenging, but that it shows my love for literature, I guess.
Yeah, but not critique. If I was just going to say that's not good for the deforestation goals that we're talking about.
Not at all. Good point.
But good to hear that you plan carefully, right? There is like a succession. There's no waste. You actually intended to read the book. So that's good. So one more thing that we would want to ask you, which is sort of like a fun, silly thing, is that we're going to ask you to give us a number between 1 and 20. And then we're going to ask you the question, usually kind of silly, correspond to that number. Why don't you give us the number?
Okay.
Pick a number out of a hat.
Yep.
7.
7. Tell us about a teacher who had a major influence on you.
Oh, wow. There's one that comes to mind. So I did my senior year in high school in Canada, in the suburbs of Montreal. And I had this history teacher, Mr. Wologovich. And I don't know why, but he had a major impact. He gave me things to read and he used to tell nice stories. I'm still a history fan to this day. So he comes to mind. I don't think he'll be listening to this podcast, but if you are, Mr. Wologovich, hello.
That's very nice. Well, look, it's been wonderful speaking with you, Eduardo, and we really appreciate it. Thank you very much for appearing on the show.
Thank you. Thank you all for listening in. Thanks, Anora. Thanks, Barry. It was a pleasure.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.